have to say that the technology is that we are obviously sending this out live as well. So if you see any interaction with our wonderful gentleman in the centre, that's why. Thank you. Distinguished guests, ladies and gentlemen, it is a pleasure and privilege to welcome you to Hampstead Synagogue, whether you are with us in person or online, on this occasion of the 19th annual Isaiah Berlin Lecture. This introduction would normally be given by our rabbi, Dr. Michael Harris, who is sadly unwell and therefore unable to attend in person, but is with us online. A word of background about this annual lecture. Sir Isaiah Berlin was a member of our synagogue, the family's membership having begun when his parents joined in the 1920s. After Sir Isaiah's death in 1997, we were privileged to provide the venue for a very special memorial service. But we felt that Sir Isaiah's connection with our shul should be marked in a more permanent way as well. And so we approached Lady Berlin and the members of Sir Isaiah's family to ask if they would agree to our synagogue holding an annual lecture in Sir Isaiah's memory. We were delighted and honoured when they consented, and we thank in particular Sir Isaiah's stepson, our dear friend Mr. Peter Halban, for his close cooperation in making the many arrangements for the lectures each year. And our sincere condolences, Peter, to you and the family on the loss last week of your brother Michel Strauss, and we wish you all only blessing and happiness in the future. We also thank Zaki Cooper for his ongoing hard work, dedication, and expertise in spearheading the organisation of the lectures and invitations to our speakers over so many years. And our thanks also to Henry Grunwald for securing for this evening a further most outstanding and eminent lecturer, Baroness Hale of Richmond. This week's reading from the Torah throughout the Jewish world is named Chaya Sarah, the life of Sarah. Yet the reading begins with an account of Sarah's death and burial. The resolution of this paradox is that outstanding people and their ideas live on even after their physical departure from this world. Such is certainly true of the philosophy of Sir Isaiah Berlin, which remains so relevant and necessary in our troubled contemporary world. Zaki Cooper will now introduce this year's Berlin lecturer, Lady Hale.
Good evening, ladies and gentlemen. It's my great pleasure to introduce Lady Hale of Richmond to deliver the 19th Isaiah Berlin lecture. This lecture series all started in 2003 when Chief Rabbi Sachs gave the first lecture. And tonight we're delighted to welcome Lady Hale. So you could say we've gone from the chief to Hale, or looking at things backwards, Hale to the chief. It's a particular delight to be able to do this as a hybrid event, as last year we were fully online for Philippe Sand's lecture. Growing up, we all had our favourite superheroes. Superwoman, Batman, Wonder Woman. But tonight, we are delighted to be able to welcome Spider-Woman, the title of Lady Hale's autobiography just out. Famous for the brooches she wears, Lady Hale is only the third person and the first woman to serve as president of the Supreme Court of this country. She spent her childhood years in Richmond, North Yorkshire, and after studying at Cambridge, was called to the bar by Gray's Inn. She then taught law at Manchester University for 18 years, specialising in family and social welfare law, and also practised at the Manchester Bar and authored a number of books. In 1984, she became the first woman to serve on the Law Commission, where she led the work that resulted in the Children Act 1989 and the Mental Capacity Act of 2005. She was also a founder member of the Human Fertilisation and Embryology Authority, and in 1994 was appointed a judge of the Family Division of the High Court, and then to the Court of Appeal in 1999. 5 years later, she became a Lord of Appeal in Ordinary in the House of Lords. This role evolved into becoming a Justice of the newly established Supreme Court in 2009, and she became Deputy President of the Supreme Court in 2013, and 4 years later she became its President. During her 4 years as President, most famously, she and her fellow justices ruled that the Prime Minister's proroguing of Parliament over Brexit was unlawful. During her incredibly distinguished career, she has acted as a champion for women in the law. She helped to establish the UK Association of Women Judges, as served as president of an equivalent international organisation. As well as women in the law, another area of interest for Lady Hale is religion in the law, not surprising perhaps from someone who is a practicing member of the Church of England. As a judge blessed with an outstanding legal mind and a pioneer for women in the law, a very lonely struggle not so long ago, we're delighted to have her with us. So Lady Hale, a big welcome to you and to our audience here in person and also to the many people watching online. We're really looking forward to what you have to say as you address the question, is there anything wrong with rights?
Is that all right? Okay, good. Thank you very much, and good evening to everybody, both here in the room and online. It is a great honour, but also a great surprise to be asked to give this lecture in memory of Isaiah Berlin. I am a humble lawyer, not a great political philosopher. I cannot match his erudition or his wisdom, but I hope that he would not disapprove too much of what I am going to say. Maybe Peter will tell me later. I chose this title because the idea of rights seems to be under increasing attack these days, not only from some politicians, but also from scholars such as Professor Nigel Biggar in his intriguing book, What's Wrong with Rights? But as Professor Joad would have said in the Brains Trust all those years ago, it all depends what you mean by rights. I would like to examine the meaning of rights through the lens of the rights of children, because that is a subject to which I have devoted much of my professional life. Philosophers are interested in children's rights because they raise such interesting questions about the whole concept of rights. Can you have rights at all if you are too young to exercise choice? When others have to enforce your rights for you? When the obligations upon which your most essential rights depend are often so vague and ill-defined? And when you are too young to have reciprocal obligations of your own? My answer to all these questions is yes, and that the only thing wrong with children's rights at present is that they do not go far enough. Now, we're all familiar with the concept of ordinary legal rights. I have a right not to be physically or sexually assaulted, not to be injured by the carelessness or other unlawful conduct of drivers or employers, or indeed anyone else, but the others don't tend to be insured. To be supplied with the goods I have ordered from Amazon in accordance with their description, fit for their purpose and of merchantable quality. To be given good title to the property I have bought, and so on and so on. It is clear who has the reciprocal obligation. The right is given me by the general law or by a private agreement which the law requires to be respected. Now, Professor Biggar has no problem with this sort of right, and I suspect that no one else does either. They fit within his paradigm of a legal right, quote, possessed by an individual or corporation and designed to secure an important element of human or commercial flourishing backed up by authority, end quote. Now, children can have this sort of right too, although there are limitations on their rights to make contracts or hold property, and they may need the help of others to enforce the rights that they do have. But where Professor Biggar and many others before and after him have problems is with the idea that there are rights which people ought to have simply by virtue of being human, sometimes called natural rights. he identifies a number of problems with these, which, were they indeed to be the case, would have some merit. So the problems are attributing to them the same security and stability as positive legal rights, asserting rights to liberties or benefits whose lack of definition permits ludicrous or recklessly licentious accruals, getting carried away with its own high-flying rhetoric, yeah, we all understand that, confusing a specific historical form with the right itself, asserting rights to benefits without assigning a duty to supply them to a particular body, failing to talk about the duties of the rights holder, and displaying the conclusionary force which asserts at the beginning what needs to be argued and proven. His conclusion is that there is a set of moral principles that are given in and with the nature of reality, specifically the nature of human flourishing. There are also positive legal rights that are or would be justified by natural morality, but there are no natural rights. Yet the international community and many nation states have long behaved as though there are such rights. They call them human rights. The Universal Declaration of Human Rights of 1948 proudly declares that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. I'm sure these days they would say sisterhood too. It goes on to list a great many rights: the right to life, liberty, and security of person, not to be held in slavery or servitude, not to be subjected to torture or to cruel, inhuman, or degrading treatment or punishment, or to arbitrary arrest or detention, the right to a fair and public hearing before an independent and impartial tribunal in the determination of civil rights and obligations and any criminal charge, and to rights such as freedom of thought, conscience and religion, freedom of opinion and expression, freedom of peaceful assembly and association, and many more. Who can quarrel with any of that? The Universal Declaration was not binding in international law, let alone in the national laws of the states parties. But its translation into the International Covenants of Civil and Political Rights and Economic, Social and Cultural Rights of 1966 is binding in international law, as is its regional expression in the European Convention on Human Rights of 1950. However, in the Anglo-American legal world, treaties do not become part of the national law unless and until the legislature adopts them in whole or in part. The government can make or unmake any treaty, but the government cannot change the law. Only Parliament can do that. That was the point of the first case brought to the UK Supreme Court by Mrs. Gina Miller. Nevertheless, such human rights have found their way into the national laws of most, perhaps all, the countries in the Anglo-American legal world. This can happen in two main ways. In the 4 countries without a written constitution, the United Kingdom, Israel, New Zealand, and the Isle of Man, it can be done through specific legislation, such as the Human Rights Act 1998, which translates the rights protected by the European Convention into rights protected by the UK law. But of course, what Parliament has given, Parliament can take away. In countries with a written constitution, however, versions of those rights are embodied in the constitution and are not only enforceable in law, but given a special status, which makes it difficult for the legislature to remove or reduce them. So one way or another, these human rights have found their way into the positive law of most of the Anglo-American world. They do sometimes lack the precision which we prefer, but they are not alone in that. There are many laws which lack the precision which we prefer, and we judges have learnt to make the best of them. They are different from the ordinary legal rights with which I began, because they are, for the most part, rights against the state, rather than rights against private individuals or enterprises. But there's nothing new in that. We have been familiar with rights against the state since before the Magna Carta of 1215 promised that we will sell to no man, we will not deny or defer to any man right or justice. Most of these rights are negative rights, in the sense that the state promises not to do something, not to kill, torture, or enslave, or to interfere with freedoms of religion, expression, or assembly, or whatever. But sometimes they impose positive obligations on the state. For example, to have a justice system which enables people to enforce their rights, to have a legal system which protects life, to investigate deaths for which the state may bear some responsibility, or to protect vulnerable people from sexual assaults, which are a gross invasion of their right to respect for private and family life. These are duties to protect. But by and large, the European Convention does not impose positive duties upon the state to provide for people's needs. There is no right to be provided with a home, only the right not to have the home one does have taken away without due process. There is no right to be provided with welfare benefits, only the right to such benefits as the state does provide without discrimination on grounds such as sex, race, colour, language, religion, and so on. The only possible exception is the right to education, and even that is contentious. So where do children fit into all of this? After all, they are not immediately endowed with reason and conscience, although they do have the capacity to develop these. But they too have the rights protected by the Human Rights Act, although the application of those rights may sometimes be modified to take account of the different factual situation of children. Their liberty may be curtailed, for example, in circumstances where an adult could not be. But the Convention rights are not sufficient. All children have basic needs which have to be met by someone else if they are to survive and thrive. Needs for food, shelter, clothing, and dare I say it, for love. Not only that, they need education. They need to learn self-control, respect for others, how to behave acceptably in the wider community. Children must be brought up to play their part in society. It's doing them no favours to leave them without any sense of right and wrong or respect for the needs of others. But who is to provide for these needs? In Western societies, the primary responsibility lies with their parents or other family members. There is plenty of evidence that, by and large, children do best in their own families. But the human rights instruments go further than that. The Universal Declaration, for example, pronounces that the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. The European Convention goes further still and provides that everyone has the right to respect for his private and family life. The state can only interfere if it is in accordance with the law and a proportionate means of achieving a legitimate aim. This respect for the family has a deep significance in Western-style liberal democracies. The whole idea that people are born free and equal in dignity and rights is premised on difference. If we were all the same, we would not need to guarantee that individual differences should be respected. Aharon Barak, the great Chief Justice of the Supreme Court of Israel, put it like this: the factual premise is that people are different from one another. No person is completely identical to another. Every person is a world in himself. Society is based on people who are different from one another. Every person is free to develop physically and spiritually as he sees fit. This underlying freedom is the basis for the principle of equality. But individual differences are the product of the interplay between the individual person and his upbringing and environment. Different upbringings produce different people. The first thing that a totalitarian regime tries to do is to get at the children, to distance them from the subversive, varied influences of their families and indoctrinate them in their ruler's view of the world. But a nation without children is unthinkable. The Pied Piper was attacking the very existence of Hamelin when he enticed its children away. But they are not the nation's children. Families must be left to bring up their children in their own way. The Review of Child Care Law, which led to Our Children Act 1989, put it this way, quote, "It is important in a free society to maintain the rich diversity of lifestyles which is secured by permitting families a large measure of autonomy in the way in which they bring up their children." This in turn came from the well-known United States jurisprudence, most significantly the case of Pierce and the Society of Sisters in 1925. Quote, "The fundamental theory of liberty on which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." But what are we to do if the family fail in their duties towards their children? We can and do punish parents who fail to supply their children with the basic necessities of life, or to send them to school, or to seek medical aid for them, even if the latter is for conscientious or religious reasons. But punishing the parents won't help the child. So, but supposedly as a last resort, the state can step in to remove children from home if they are at risk of significant harm as a result of a lack of reasonable parental care. It's supposed to be a last resort for all the reasons that I gave earlier. But a lack of reasonable parental care is an elastic concept which can encompass emotional as well as physical neglect and abuse. But is that enough, the criminal law and care proceedings? Don't children have a human right to have their basic needs met? The most ratified human rights instrument in the world is the United Nations Convention on the Rights of the Child of 1989. The UK is a party to that convention, but has not incorporated it into UK law. The Scots are trying to do that at the moment, but they have run into some difficulties, as aspects of their bill have been found to be outside their legislative competence. Who can say what will emerge in the end? But it is in any event a controversial exercise, given the contents of the convention. Its provisions fall into three broad categories. First are those which ascribe to children the same fundamental rights as are ascribed to adults. The right to life, not to be subjected to torture or other cruel, inhuman, or degrading treatment or punishment, not to be deprived of liberty unlawfully or arbitrarily, and the rights to freedom of expression, of thought, conscience and religion, and of association and peaceful assembly. In the next category are those which give extra rights to children. Some of these are rights to be protected from economic exploitation and harmful work, from all forms of sexual exploitation and abuse, from trafficking, and all other forms of exploitation prejudicial to any aspect of the child's welfare. But others are what we call rights of recipients, rights to receive something, rights to the enjoyment of the highest attainable standard of health and to facilities for the treatment of illness and rehabilitation of health, rights to a standard of living adequate for the child's physical, mental, spiritual, moral, and social development, rights to education, and the right to play. I like that one. I think grown-ups should have it too. The primary responsibility for providing for the child's most basic needs lies with the family. But the state has a responsibility for the education and health services and to step in where the family fails. Third, and perhaps most important of all, therefore, is the guiding principle set out in Article 3.1, and of course quite different from anything in the adult human rights conventions. Quote, "In all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration." This is, of course, paternalism, or even maternalism. The child may have the same rights as adults, but others, including the state, are allowed to restrict or interfere in these in the child's best interests. But it is a benevolent paternalism, and it is tempered by Article 12.1, which requires that states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. One could say in accordance with the stubbornness of the child as well, but there we go. And Article 12.2 specifies a right to be heard in judicial proceedings affecting the child. Article 3.1 has not been incorporated into UK law, but it is supposedly reflected in two statutory duties. The Home Secretary has a duty, under Section 55 of the Borders, Citizenship and Immigration Act 2009, to discharge her immigration functions, quote, "having regard to the need to safeguard and promote the welfare of children who are in the United Kingdom," end quote. Section 11, subsection 2 of the Children Act 2004 imposes a similar duty on a wide range of public authorities, including the police. Now, the purpose may have been to implement the obligation in Article 3.1, but they don't actually say that the best interests of the child are to be a primary consideration, nor, more importantly, does the duty extend to most of central government, including the Department of Work and Pensions, although the government did say that it would abide by it. So how can we get the government to put the best interests of children first when making decisions which profoundly affect them? Some of us have tried. ZH Tanzania and the Secretary of State for the Home Department in 2011 concerned the planned removal to Tanzania of the mother of two British children who had been born in England and lived here all their lives. The mother was an illegal immigrant who richly deserved to be removed, but there was no one else to look after the children, so removing her would inevitably mean that they would have to go too, leaving their home, their schools, and their friends, and losing all the benefits of their British citizenship. the Supreme Court held that the best interests of the children were a primary consideration in judging whether this interference with the children's right to respect for their private and family lives, protected by Article 8 of the European Convention, was justified. Now, Article 3.1 of the Children's Rights Convention does not require that the child's best interests be paramount, in the sense that they are a trump card overriding everything else. They can be outweighed by other considerations, either separately or cumulatively, but no other consideration is to be taken to be inherently more important than the best interests of the child. As Lord Kerr put it, quote, "This is not, it is agreed, a factor of limitless importance in the sense that it will prevail over all other considerations. It is a factor, however, that must rank higher than any other. It is not merely one consideration that weighs in the balance alongside other competing factors. Where the best interests of the child clearly favour a certain course, that course should be followed, unless countervailing reasons of considerable force displace them." End quote. You see, Lord Kerr was stronger in his views than I was. A very good thing too. Now, ZH Tanzania has been applied in other contexts where the actions of public authorities interfere with a particular child's convention rights, and the question is whether that interference is justified, such as, for example, the extradition of parents to face criminal charges abroad, or the refusal of planning permission to travellers. There have, however, been some decisions of central government which have had a profound effect upon the lives of many children. In particular, the imposition and then the tightening of a benefit cap, which limits a household to less than the government deems that they need to live on, or the imposition of the two-child rule, which means that families are denied a proportionate increase in their benefits to reflect the number of mouths they have to feed. These have been variously challenged in 3 cases before the Supreme Court, because they discriminate against women, or against the parents of young children, or against the children themselves. The Supreme Court has acknowledged that Article 3.1 is relevant in deciding whether the discrimination is justified. But it has always found that the government was justified, notwithstanding the severe impact upon children's welfare. And it has recently emphasised that the question is not whether the UK is in breach of its international obligations. It is not the job of the courts to decide that. The court's reluctance to intervene may be understandable. After all, they are dealing with the allocation of very large sums of public money, and that is constitutionally a matter for government rather than the courts. Although it doesn't take much imagination to realise that there must be limits to the discrimination which is justified. We would not, for example, countenance a law which gave benefits only to women and not to men, would we? Or the other way round. However, that is a very large gap in the protection which is afforded to children's rights as we understand them. And what about when we are dealing with an individual child's civil liberties? In a case of the Queen on the application of Castle against the Commissioner of Police for the Metropolis, the plaintiffs were Adam Castle, aged 16, Rosie Castle, aged 14, and Sam Eaton, aged 16, who took a peaceful part in a demonstration against the proposed increase in university tuition fees. The march started at Trafalgar Square and proceeded down Whitehall towards Parliament Square. It was largely peaceful, but there were some violent incidents. The senior police officer in charge decided that a large group of between 3,000 and 5,000 demonstrators should be kettled in Whitehall. You know what kettling is? It's keeping people in a confined space. Rosie was kept there for around 6.5 hours. Adam and Sam for between 7.5 and 8 hours. It was November and the temperature inside the cordon was near freezing. After some hours, one toilet was provided. There was no food and water. The children were shivering and very distressed when they left, and now said that they no longer felt able to take part in peaceful protests for fear of being kettled again. They argued that this was a breach of the police's duty under Section 11, subsection 2 of the Children Act 2004, to make arrangements for ensuring that their functions are discharged, having regard to the need to safeguard and promote the welfare of children. However, the High Court held that it was reasonable for the police not to plan ahead for the possibility that kettling would be necessary and the likelihood that children would be among those kettled. This was a demonstration about university tuition fees, for heaven's sake. Was it not foreseeable that there would be people under 18 who were involved in said demonstration? Because, of course, it affected them more than almost anybody else in the world. But it was reasonable not to foresee all this and not to make any specific arrangements for children. Yet surely promoting the welfare of children includes promoting their right to engage in peaceful protests, facilitating their development as active democratic citizens, not just protecting their physical safety. Nor should they be deterred from playing a part in the democratic process, for they may then become disengaged when they do grow up. It will be apparent from all of this that I do believe that there are rights which all people ought to have simply because they are human. Those are the rights which the international community has identified in broadly similar terms in a number of binding instruments. For the most part, they have become part of national law. For the most part, they are rights against the state, so the holder of the corresponding obligation is clear enough. And the courts have been able to apply them without too much difficulty. There are also extra rights which children ought to have, simply because they are children, because they have needs which they cannot or should not be expected to provide for themselves. They need extra protection from certain harms, and they need to be supplied with certain good things. Their parents are the primary holders of the corresponding obligations, but if the parents fail, then the state has a duty to step in. So far, probably so uncontroversial. But do children also have the right to have the state make their best interests a primary consideration in all actions which concern them? The United Nations says that they do, but it appears that we have yet to be convinced of it in this country. If there is anything wrong with rights, then that is it. Thank you.
Thank you very much, Lady Hale. Thank you very much, Lady Hale. We're now going to take questions. Some of the questions will be taken online and some of them will be taken from the room. So we'll start with the gentleman over there. There is a mic, if you're happy to use a mic. Thank you.
Hello. Thank you so much for a really interesting lecture, and I really liked your conclusion. I'm a practicing paediatrician in East London. and I suspect I know what you might say, but the right to vaccination, I see children come to harm, including death, from not being vaccinated. Do you have any views? The current law says that parents can decide. And then at the opposite end of the spectrum, teenagers who are gender dysphoric, very mentally disturbed, have no diagnosis because they've not met with psychiatrists. There's a long waiting list. Schools and other institutions validating the child, changing their sex, etc. And the loving parents feeling that they're not in control of their child, who they love. Not necessarily resisting this, but the state has taken over and pushing care in a way that perhaps from their perspective is not right or going too fast. Lots of other questions, of course.
Oh, could I do that? Yes. Well, thank you. Those are two fascinating questions. As far as the right to vaccination is concerned, well, I would obviously take the view that if the child is old enough to understand the pros and cons of vaccination and to make his or her own choice, well, that should be the child's choice and not the parent's choice. If the child is, and that is probably the situation with everybody for whom vaccination is currently an option. So that I could stop there. Yes. If the child is not old enough or for some reason lacks that competence, well, then the question is whether failing to vaccinate the child is actually harmful to the child. And there's a great deal of evidence that it is harmful to the child. I mean, you are more expert in this than I am, but then if it's an emergency, of course, it is possible for anybody to do what it is reasonable to do in the circumstances. So you don't have to go to court. If it's not an emergency, well, then going to court is the way to solve the problem. Of course, it isn't a good way of doing it, but the threat of going to court is usually enough to secure cooperation. It might be even better if there were a positive law about it. But the tools are there, the theory is there, there's not a problem in theory. I think with gender dysphoria, there is probably a theoretical problem. And I don't want to get drawn too much into that very thorny debate, not only because it is before the courts at the moment. I don't know whether the Wells case is going to go to the Supreme Court. Mr. Rosenberg may know. But I don't know, but it has gone from the High Court to the Court of Appeal. Court of Appeal decision is quite recent. So it's a very fraught area as to basically what the state should be providing for the children who want it, whether or not their parents want it. That's the question you're asking, really, isn't it? Yeah, of course. Yes, well, I think it's the job of the health service to protect them and to take steps to protect them if the parents are proving intransigent, frankly. That's what I think it is. As I say, the gender dysphoria is extremely complicated because you have the conflict between what might be a completely genuine situation on the part of the child and the parents feeling that things are going too fast, or sometimes not going fast enough. So the real answer is almost certainly the greater availability of much more sensitive services so that this can be properly explored. But as you know, the High Court held that basically no child under 16 was likely to have competence to consent to puberty blockers. And even with 16 and 17-year-olds, it might be necessary to go to court. The Court of Appeal has said something rather less than that, which may or may not be helpful, I don't know. So that's why I don't want to get into too detailed a discussion of a really complex subject. But we recognise the complexities.
I'm going to take another question from the room. Could I take Jerry at the back, please? Could I ask you, there is a mic going round, and try and keep your question as brief as possible. Thank you.
Baroness Hale, Lady Hale, delighted for your beautiful exposition this evening. Two very minor questions. One, you spoke about protecting communities and children especially. Can I wind the clock back and take you back to the very difficult decision for our community on the JFS issue, which you may well recollect, where there was a conflict between what religious groupings, such as the Jewish community, wanted and the decisions that were taken by the court, which have had to make significant changes for Jewish education in this country. And the second issue, very minor one, of course, do you find it difficult to see where there are ministers of justice, and this has happened in Israel as well, trying to involve themselves in the role of the Supreme Court in trying to politicise the judicial system? Dominic Raab is hinting at doing a similar thing here. Thank you.
Thank you. You will forgive me for not commenting on the JFS case, won't you? Frankly, I was part of the majority which held that the particular criteria for entry to the JFS was discriminatory on ethnic grounds, a conclusion which it was very hard to escape. The fact that it was not wanted by that community did not mean that it was not wanted by other people, as you can imagine, otherwise the case would not have been brought. So I can't do anything more than say that was the decision. We explained ourselves in great detail, and I would stick by it. I sometimes think my decisions are wrong, but I don't think that one was. As far as the Minister of Justice trying to politicise the judicial system, it is undoubtedly the case that certain types of judicial decision involve the courts in making decisions which the politicians don't like. It is an inevitable part of the role of ensuring that public authorities and government ministers act within the law. And that is an essential part of the rule of law as we understand it. From time to time, of course, those decisions have important political ramifications. They often don't, but from time to time they do. But the judges can't duck their role of ensuring that the public authorities act within the law simply because there are political ramifications. The judges are not concerned with the political ramifications. That's not what we're for. We're concerned with the legality of what has been done or is proposed to be done. At the moment, we have a system of judicial appointments in which the politicians play a very, very minor role. In fact, it's quite extraordinary. Under the Constitutional Reform Act, we went from a position where judicial appointments were largely in the hands of a politician, the Lord Chancellor, to a situation in which judicial appointments are very largely in the hands of an independent Judicial Appointments Commission. Most of us think that that was a very good thing, although there's very little evidence that the Lord Chancellor behaved in a political way. We don't think we've had political appointments in this country since at least the Second World War. I got 4 judicial appointments under the old tap-on-the-shoulder system, and 2 of them were by Conservative Lord Chancellors, and 2 of them were by Labour Lord Chancellors. Sort of situation that couldn't happen in the United States, but I'm very proud of the fact that it can happen here. But of course, the last 2 appointments that I had were through an open and transparent merit-based application system where I had to put in an application form and put in samples of my work and generally prove myself to an independent appointing commission. Of course, a lot of people don't like that. They prefer the old tap-on-the-shoulder system if they were pretty sure they would be one of the people to be tapped. But by and large, I think most of us think that our present system is an improvement on the previous system, and it has greatly increased the diversity of the judiciary. And there is still the potential for even greater diversity. So most of us would be very opposed to the politicisation of the judicial appointments system.
Thank you. There was a question over here. Daniel, the mic will come to you.
What some critics might say about human rights is that it gives quite a lot of power, obviously, to the judiciary, especially when human rights really are living instruments and the judiciary will look at them and apply a certain values-based judgment. If you look at some of the jurisprudence of the Supreme Court recently, especially the Shamima Begum case, it's very difficult to imagine that decision being made by yourself and Lord Kerr. And I just wonder if that's an example of why people may not be as happy with human rights as they could be, because you can have such significant variations according to the panel who hear a case.
Well, you can say that. I couldn't possibly comment. That gives the answer. It is undoubtedly the case that the qualified rights, beginning with Article 8, so the right to respect for private and family life, and then going on to the rights to freedom of religion and freedom of expression and freedom of assembly, and of course freedom, the right to enjoy the rights without discrimination. All of those are qualified in the sense that they can be overridden if there is a legitimate aim and the means chosen are a proportionate means of achieving that legitimate aim. Or, as it's sometimes put, a fair balance has been struck but between the rights of the individual and the interests of the community or other individuals. That is an inevitable concomitant of protecting human rights. It does mean that courts are from time to time drawn into judgments, but it's not unusual for courts to be drawn into judgments. We do it all the time. I spent most of my life as a trial judge deciding what would be in the best interests of a child. That included all sorts of value judgments. They were difficult ones, and they were ones with which reasonable people could disagree. So I don't think that that is an inherent objection to trying to do our best. And the very best protection that we have is that appellate decisions are made by a group of people. It's not just Brenda on a frolic of her own, or even Brian on a frolic of his own, or Nicholas on a frolic of his own, or any of the others. it is a collective decision, and collective decisions are, on the whole, better decisions than individual decisions. So I understand the criticism, but I don't think it's a valid one.
Yes, over here. Thank you. Could you just wait for the mic so that we can... Thank you.
You mentioned the politicisation of appointment in the United States Supreme Court.
I didn't mention that.
You contrasted the lack of politicisation. I just wondered whether you feel that the reputation of the United States Supreme Court has been adversely affected by events of the last few years, and particularly the circumstances surrounding the appointments of judges and the processes by which they were selected and appointed to the bench. Whether that you think that's had a particular impact in the last few years compared to the past.
That's a very difficult question to answer at the level of the knowledge that I have, because I think that you can obviously criticise the appointments process, and you can certainly criticise the way in which it has been done in recent years. You can, obviously, the Senate not cooperating in President Obama replacing Justice Scalia when he sadly died, contrasted with the speed with which they cooperated in replacing Justice Ruth Bader Ginsburg when she sadly died. So yes, you can criticise the process, but as with so much in the justice system, the proof of the pudding is in the eating. What about the decisions? And there have been some politically appointed justices of the Supreme Court of the United States who have turned in to the most surprisingly liberal decision makers on that court. There is something about the office, and there is something about a lifetime appointment to that office that induces independence of thought and distances you from the reasons why you are there. Now, I'm not going to say that that's a universal truth. I'm not going to say that it will generally be the situation. But the test of whether a court is worthy of respect is the quality of its decisions, rather than the way in which it was appointed.
If I take the one at the back and then here, there's two gentlemen here. Thank you.
Lady Hale, I would like to ask you a question, if I may, about the assisted dying bill. This week it's been reported that two former law lords have expressed support for the bill. Lord Neuberger, and I may quote him very briefly, says, "If you want to end your life, you are entitled to do so. And if you have a fundamental right to end your life, you must require very powerful reasons why you should be denied assistance if you need to exercise that right and cannot do so without assistance." He was also supported by Lord Etherton, a former Master of the Rolls. So my question to you is this: do you agree with these two learned judges, or rather with the three faith leaders who spoke out this week with strong reservations about the bill? And if the issue came to be tested in the Supreme Court, what would influence your decision?
Well, I am no longer a member of the Supreme Court, having retired therefrom, having reached the mandatory retirement age of 75. We had exactly that case in the Supreme Court. In the case of Nicklinson and others, about 4 or 5 years ago, something like that. And there were 9 justices who heard the case. It was always a case in which the law would be made by Parliament. The law is contained, the absolute ban on assisting suicide is contained in an Act of Parliament. And the court cannot change an Act of Parliament. That is a difference between the Supreme Court of the United Kingdom and the Supreme Court of the United States, and most other Supreme Courts in the world. So the most we could have done would be to make a declaration that, in our view, the current state of the law was incompatible with the human rights of the people who had brought the case. Two of us thought not only that it was incompatible, because there was a right to choose the time and manner of one's own death, and would have made a declaration of incompatibility. Three of the other justices considered that that was likely to be the case, but they would not make a declaration of incompatibility because the matter was currently coming up before Parliament. The four others thought it was solely a matter for Parliament. That was the situation in the Nicholson case. I have not changed my view. You can go and read my judgment. I have some reason to believe that the contents of the current bill derive something from my judgment, because the safeguards proposed are exactly the safeguards that I suggested would be possible were the law to be changed. What would happen if the case came again before the Supreme Court? I have no idea, but my guess is it probably won't. They'll certainly wait and see what happens to the current bill.
Thank you. Gentleman here. Yes.
Can I ask you about transparency in the family courts? Well, can I ask you whether you think that the rights of the child, which is the subject of your lecture, would be damaged if it was possible to report more of the family courts than it is at the moment? Is there an acceptable compromise towards open justice that wouldn't damage the rights of the child?
Well, that is a very good question, Joshua, and I have a feeling that I gave an even longer lecture than this one on that very topic not very long ago. So you better go and read that lecture in case I say something inconsistent. Clearly, it's a very important protection, not only for the rights of the child, but also for the rights of the family, that there be transparency in what goes on in the family courts. I think I have made no secret of my fear that once the authorities get their claws into you, it's really quite difficult to get them out. I don't think I've put it in quite that way. but particularly in cases of the risk of future emotional harm. Now that seems to me to be a very problematic concept. You know, who are we to interfere in a family on the basis of a risk of future emotional harm, unless it is at the very extreme end of that, and the risk is very clear. So there are cases where I think it is. There are cases where the authorities don't interfere quickly enough, when it's absolutely apparent that they should have done. And there are other cases where they've got a reason to interfere and then they can't give up. So, yes, transparency is an important protection. And of course, it has been secured now by the right of the media to attend. And it has been enhanced by the much greater publicity given to judgments in the family courts. However, the children are not at all happy about this. The children are very unhappy because they worry that their family lives are going to be broadcast to the world, to the people they know, and all this anonymity is a complete farce because anybody is going to be able to put two and two together and put the jigsaw together and work out who it is. And some of the details, of course, in these cases are distressing in the extreme. Some of the things that people do to children are almost literally incredible. but they happen. You had irrefutable evidence that they had happened. The paediatrician in the room will know that that is the case. And for the child concerned, who has been rescued from that situation, to have the ghastliness of that, broadcast, even available for the child to read, is distressing. So I think the present compromise is okay, but huge care has got to be taken to make sure that there is anonymity, even possibly telling a few lies about where things took place. You could pretend it was at the other end of the country or that sort of thing, because that's immaterial to what we're talking about. And as is the case with some other types of litigation, it may be necessary to have an open judgment and a closed judgment. After all, that happens in national security cases, and the protection of children is just as important, it seems to me. So, yes, it's a work in progress. But it's a huge improvement, Joshua, over how when I became a family division judge, everything was in private, and it was entirely up to the judge whether the judgment was published or not, which, of course, is a recipe for the judgments about which one was least happy not being published. I'm sure that never happened, of course. Never, ever happened. But we also know that there are, as I say, there is this problem of overzealousness as well as not zealous enough. So, yes, transparency is important.
Thank you. There was a lady here.
Lady Hale, I wonder if you would be prepared to comment on the very peculiar English-British situation of the relationship between convention and law. One of the great conventions that existed until recently is arm's length appointments. Perhaps your experience in the old system under two politically different Lord Chancellors is because they were absolutely devoted to the principle of objectivity under old conventions. But here we see some recent appointments, not in the law, but in other areas of English life, that conventionally were supposed to be independent, but are now very party political. Are you worried at all about the glorious independence of the British judiciary?
I'm not worried about the glorious independence of the British judiciary.
Well, no, I don't mean the characters of the people.
No.
But unless the system is changed to be more politically responsive.
At the moment, the system of judicial appointments is laid down in statute. Mm. So the Constitutional Reform Act would have to be changed very dramatically in order to increase the level of political involvement in judicial appointments. Of course, it could happen, but it would take a long time, and it would be very difficult. And there are also some changes which would be not as bad as others, if you see what I mean. It has been suggested that especially for the Supreme Court, the appointing commission could, at the moment, the appointing commissions put up one recommendation per vacancy. That's great, because it means the government's got virtually no choice. It can just say yes, no, or maybe. And it almost always says yes. Just occasionally says maybe. And if it says no or maybe, it has to give reasons. So that's subject to judicial review, etc., etc. If the system were to put up more than one candidate, thus giving the politicians a choice, well, you can see the dangers of that, can't you? but it is the situation in other good countries like Canada, so it's not necessarily as dangerous as all that. But I think most of the judiciary would be against any greater political involvement. And I'm not going to comment on other sorts of public appointment because they're not subject to the same protection that judicial appointments are.
We'll take a couple more questions. Max.
I'd like to get back to family law, if I may. Given that we are living in an age of gender fluidity and that in the decades preceding the arrival of this fluid state, we saw the breakup of the nuclear family at an increasing rate of knots, and given that we have a human right to family life, how does the law define the family?
Well, if we're talking in terms of the Human Rights Act, generally speaking, there is always family life between parents and their children. And that includes unmarried parents and their children. And it seems to include them even if they haven't actually lived together. Seems to. Not always predictable in these circumstances. After that, it gets a bit more difficult. Husband and wife, of course. Couples who are living together, yes, they have family life. They did get round to saying that same-sex couples had family life. That took a bit of time, but they've more or less come to that now. And then sometimes there are other people who have family life, such as grandparents or foster parents or other people who've been looking after or living with the child. So it is quite a fluid concept and tends to be case-specific other than those taken for granted categories.
If you turn it round and ask about the right of the child to family life in the case of breakup, and then there's a need to remove question, then it becomes complicated.
Well, of course it does. These are always complicated. I mean, because if you have a broken family and then one of the parents, the parent with whom the child is living, wants to go and live in another country, then the other parent doesn't agree, well, then the court has to decide where the best interests of the child lie. And it's not easy. I don't myself think that it's helped by any sort of rules of thumb or presumptions, because every case is different. And to my mind, it would be very different if the parent with the children wanted to go and live in Ireland from what it would be if they wanted to live in Australia. To take a simple example. And, or if they wanted to live in a country that was not party to the various international conventions under which court orders can be enforced, recognised and enforced, that would be very different. Well, there are all sorts of circumstances which one could composite in which it would and would not. In the end, it's what's best for the child that is the right answer, without preconditions, it seems to me.
We'll take one more question. There was one at the front.
Lady Hale, thank you very much for your lecture. Turning in to children, I was struck by a piece I read about what China was proposing to do, with two proposed laws relating to children. One was to make local authorities check the amount of time children were being forced to do homework, extra tutoring, and force them to have a period of non-work play and playtime. On the other hand, they're proposing to make parents responsible for children's antisocial behaviour and misdemeanours and low-level crimes. Are those both just examples of a completely different non-Western, non-Anglo-American system, or is there something in either of those bills, perhaps more likely the first than the second?
Well, I think you're right that this is a level of micromanagement of family life which would not go down well on the whole in a Western liberal democracy. But I don't think it's an unknown principle that parents may from time to time be responsible for the misbehaviour of their children. There are actually some tort cases which have made parents responsible if they haven't kept proper control of their children or let them have access to a gun or something like that. So it's not a completely unknown principle, it's just that we haven't turned it into a sort of everyday law of the sort that would be enforced in the way that the law in China can sometimes be enforced.
I'm going to take one last question from online. Benjamin Crown asks, a lot of work has been done in recent years around improving communication and public understanding of the law, much of it by bloggers on Twitter, journalists, etc., as well as independent projects like Bailey. Do you think there is more of a role for judicial institutions to drive this, as opposed to relying on the goodwill and enthusiasm of a relatively small number of individuals?
Well, I think the judges do their best to try and participate in public education about the law. After all, why am I here? And there are many other similar activities in which I engage. So I think quite a lot of us do our best to do this. But I don't think it should be compulsory. I do think there's a really big need to try and engage people generally in an understanding of the importance of the law and the legal system for everybody. It's not just the criminal law that punishes wicked people or fails to punish wicked people. The law touches every aspect of our lives. As Aharon Barak said, the law is everywhere. And it would be a great good thing if people knew this. It would be a great good thing if they knew more about our Constitution in school. I think it should be part of the curriculum to tell people. Well, I think the history curriculum should have the 17th century for a start, because that's the foundation of our Constitution, and then there should be some top-up about how it's got modernised since then. I think absolute minimum that people should understand the basis of our Constitution and how it works. Not in nasty, highfalutin, complicated terms, but just the basics of it. I think the understanding that we have a justice system, that we need a justice system, that it's there for everybody, is really important. So that's going to be my next book.
Before I thank Lady Hale, can you hear me clearly? Yes. Good. Lady Hale, on behalf of Isaiah's family, I would like to thank you so much for giving us the pleasure to hear you tonight, and above all, for coming in person during extraordinarily difficult times. It was particularly important and appropriate that you decided to orientate your talk on the rights of children. But I think your warnings, and indeed your positive thoughts, remind us that woe betide us if we start to forget about the rights of children. It will lead to the abuse of society. Thank you for your clarity of thought and for your wisdom. Now let me answer your question at the beginning. I can assure you that not only would Isaiah have agreed with every word you said, he would have taken you aside and you would have spent days discussing your thoughts. They are preoccupations. What you talked about tonight, one of the fundamental core preoccupations that Isaiah, together with rights, added liberty and pluralism. And you have indeed talked in the spirit of my stepfather. Thank you very much. I would also like to thank Once again, Rabbi Michael Harris, we wish him good health. Henry Grunwald, Zaki Cooper, Madeline Abramson, and the whole team of the synagogue for once again gathering us through Lady Hale this evening to what I always call celebrating the life of my stepfather. Thank you very much.
Peter, thank you, and may I begin by thanking you and the family again for supporting this lecture for so many years, and particularly in the difficult personal circumstances of your family loss. Thank you for everything that you have done. This may be the 19th lecture. We hope there'll be many, many more ahead that we can work on together. Master Hale, if I may call you that, because we're both benchers of Gray's Inn, it's been absolutely fantastic that you've come here tonight. I was going to say something about how I anticipated what you were going to say would have met entirely with the thoughts of Sir Isaiah, but Peter has done that very, very clearly, and there's no need for me to do so. It's almost 63 years to the day since he delivered the inaugural lecture at Oxford entitled The Two Concepts of Liberty, and it still makes fascinating reading to this day, and I'm sure that it's something that you have read in the past, because you have shown us tonight, well, you've shown us a number of things. First of all, you've shown us the nonsense of there being a mandatory retirement age at 75 for judges. You know, it's utterly nonsensical that someone of your abilities should have had to step down from your role at the comparatively young age of 75. But you've also shown us how it's possible to talk on the law to an audience not composed entirely of lawyers. There may be many lawyers in the room here tonight, and amongst the hundreds who I know are watching online, but everyone will have been able to follow exactly what you have said. There have in the past been lecturers about whom one has not been able to say that, even amongst the wonderful ones who've given this lecture in previous years. You speak of firsts, and Zaki mentioned firsts. Your book, Spider-Woman, is an inspiration to all. My younger daughter's at the bar, and you met her husband before. She is a great fan of yours because you have shown just what women can do at the bar and in other professions. No ceilings. No ceilings has really meant something to you. So you were the first girl from Richmond High School to go to Cambridge. You were the first girl from Richmond High School to study law. You were the first woman, as Zaki said, to become a law commissioner, the first woman to become a Lord of Appeal in Ordinary in the Appellate Committee of the House of Lords, and the first woman to serve on the Supreme Court and, of course, be its president. We've had judges before. We've had women before giving the Isaiah Berlin lecture. You can add to your list of first. You're the first woman judge who's given the Isaiah Berlin lecture. You also, in your book, speak about imposter moments. And many of us may have heard that wonderful Desert Island Discs that you did recently, and you spoke about that there. And that, if I may say, is a sign of the enormous humility and humanity of which you are so greatly possessed. Because you say that at times when you've done this or been appointed to that or been told that, you have to pinch yourself and say, am I being an imposter? Is this really me? Do I deserve this? Can I do that? And that's a sign of a deeply modest person. And when that is combined with the great intellectual and legal rigor that you have brought to all of the courts in which you have sat, we should all be extremely grateful for that. And thank you again for joining us here tonight to give that lecture. I just want to end, before everybody gives you applause, by repeating the thanks that have been expressed to everyone at Hampstead who's made this lecture happen. We've had packed halls for this lecture in the past. We've probably got more than a packed hall amongst those who are watching online. But it's not easy to do these hybrid events. And I want on everyone's behalf to thank all of the team at Hampstead, I'm not going to name them again, who helped make tonight happen, because it's not easy, but it's been a great success. And we hope that the 20th Isaiah Berlin lecture next year will have everybody in person together. We hope you might even, I'm not going to tell you who the lecturer is, we have found him. It is a hymn next year, but I'm not going to tell you who it is, but perhaps you might even consider joining us next year. So once again, on behalf of everyone here tonight, thank you so much. And I think that here there is just a little gift for you, which we all hope that you will greatly enjoy.
I'm sure I shall.
Thank you very much.
Very much.